Hey everybody. Hello. Hello guys. Tonight I decided to do the reaction of Woody and also Jeffrey during the time when they were playing the interrogation video. So I wanted to do that today as a because since we didn't have much in court was pretty boring. Someone did do a clip for me, and I'm gonna play those clips today. Um, Today was very, very boring, Rico. Recot. It was very, very boring. Hey, 301 OG. Hey, Adrian. Hey, Benny. Hey, Mac. Tough. Let me see. Let me go back up. Hold on. Let me go up. Hey, Bree. Hey, BB. Hey, Cabell. Hey, Classy Coco. Hey, Mac Tuffy. Hey, Tall Glass. Hey, Kiki. Hey, Benny. Hey Bree. I said Bree already, right? Yeah, he was up there at the top. Hey Miss Wright. Hey PD Broker. Hey Adrian. Hey Kay. All right, everybody. But before I do all that, I wanna tell you guys how awesome you guys are. I got a call from one of my wonderful subscribers, and they called me and told me, they asked me, what did what kind of camera do you currently have? And I gave them the camera name and everything. So they said they decided to they decided they decided to get a camera. Not only did they get a camera, y'all, they got the SD cards, they got well, this is a camera. I got this camera. Gave me this camera, right? They gave me this tripod, the tripod, right? They gave me extra batteries, of course, extra battery. They gave me the the backup drive, 5 terabyte. Gave me that. And then they gave me all of these SD cards, 128 gigabyte. They gave me all of these. You see? Okay, y'all. I'm sorry, but y'all know how I am. Um, I'm blessed. I'm truly blessed. I'm truly blessed. I'm blessed. All out the blue, y'all. All out the blue. Let me just get myself together for a minute, guys. Just give me a minute. All right, I'm going to go ahead and play these videos, okay? I'll get myself together.
Ladies and gentlemen, this might be the appropriate time for us to recess today on Tuesday. Go ahead and just recess into the whether you need it or not, you just anticipate. Ladies and gentlemen, any issue remark? I apologize for the heat. I have used for our space to be heat and for that. So, okay, so unless you have anything to review, and you go back to your headquarters, you not leave your notepad in that. Not having conversations about online. Recast any kind of review, testimony, you notes with each other, she was not to consider this case in a manner and fashion and get back to the stage. So the advisor should be engaging. Remember, ladies and gentlemen, you are not permitted to make any scenes or any locations that you can heard testimony on this far. And also, it would be a violation for you to go to these places and draw, take photos, or discuss with your colleagues in the back. Any such knowledge you may have, you only consider what's being presented. So in that respect, you're also not to third-party sites, and consulting reference materials, call a friend or anybody else to otherwise aid or augment your understanding within this quote. You can only consider what's being presented in the situation. And remember, ladies and gentlemen, the big one, you can also be on the more time on social media, or the news media with your casual accounts, presented in court for your consideration. Ladies and gentlemen, lastly, the third party should try and reach you, reach you, approach you in any way, in respect to what's going on in the street that you're involved with. You were to let myself and start meeting. And then lastly, ladies and gentlemen, thank you for your patience and thank you for the attention that you've given. Otherwise, we continue to move consideration time. Is there anything else in me for today? All right, ladies and gentlemen, we'll see you tomorrow morning for 9:30, and we'll see what the day is tonight. All right. All right, ladies and gentlemen, you can see that the jury has left us. So,
the for the January 28th, that we're seeing
for January 2015.
Yeah. 21st, 2015, the portion of the we can look at hopefully decide which one we agree with.
Any council, any issues as to relate to property.
Okay, y'all. Let me go ahead on and show you what we have for today with Jeffrey. Let me just finish this from yesterday.
The state has given me proposals for the two tenders that the state has been thought the proposals about the two that they're planning on going into.
Usually what the testimony is using the play the entirety of it. There may be some one or two issues that go through again, but and but there are some things like this to look at. Look at.
I would like to my colleague.
How long is the interviews on the 28th of January? First.
January 28th is approximately a little shy of 3 hours. And February. Probably around the same time.
Um, and, can you tell me the June 10th, what year interview?
June 2015 is not.
Okay,
Both using the state, but I'm coming off of.
We probably will depend on how much. We did not post October division was open, so it would depend on.
but at least these three, you're planning on, have you identified opportunity, other than, have you identified those portions that you believe to be objectionable on January 22nd, Thursday, 21st, interviews, Mr. Shaw?
We have not identified any of it to the state. I have to check my notes and remind myself to work on that in the past. But let me just, before we go too far down the road, let me just say that, on behalf of Mr. Stillwell, I'm maintaining all objections to lack of foundation or prior inconsistent statements to be said. So,
As a general,
I'm answering these questions, but I don't want it to be perceived that I'm waiting.
Yeah. I think that your position is very clear, and I'll of course get, with any objections you may have. In addition to the ones that you've already made, I'm sure you have, but the court's just trying to figure out is whether or not you can identify those particular sections that you know you need, that you need to be, they need to be.
And I believe when it comes to the February 21st statement, just listened to the other day, I think that it's going to be less of that. Matter, less of the objectionable material in it than the January 28th. That's going to be more.
Okay, so what about the January 28th?
Going up from that, so we say, but I believe that that's one of the more wide-ranging interviews where different topics are discussed. And hearsay matters are discussed, and speculation, all of it.
Does anybody else have any comment on the 28th of January, or the 21st interviews? From your eyes, Mr. Steele.
I do. Sir, I don't believe that
the burden should be on Mr. Williams to send the state, we believe should be redacted, because the state's going to try to introduce the evidence, and there are parts of both of those statements which I have gone through, and I have delineated much of these topics or these recordings that should be struck. But I like some of the stuff that I've struck, so if the state doesn't strike it, I just won't object to it. But I don't believe that I should go first and have to do that work. So I have the court to do what it originally said and ask the state to furnish the accused, and then we can move down from there. Now, if that's contrary to the way Mr. Sharp wants to do or anyone else, I will bow down to them, but otherwise, I believe that that's the proper procedure. The reason I say that is because if I was trying to introduce an item, I don't just take the item, which I know, back and say to the opponent, hey, here's everything. Then you tell me, and let me see if I get something that I like getting because you don't catch it. I don't think that's how it's supposed to be. So I think a good thing for me and redaction by the state needs to be done first. And for English, I know we objected to it, but now that you heard it, I'm assuming you didn't hear that recording from February 20th, 2015. Then the state's exhibit number 378YC. And just, it's just obvious, even to a casual observer, that the police officer was speaking a great deal, talking to Mr. Copeland, saying, this is your first child, do you think you'll be able to see your child grow up? I know you had nothing to do with this, you were defending yourself. That should never come in, and that's what we objected to before. And that's what I think that the state has to say, just like you started to this morning. Why is it a prior instance? Why is it contradictory to the testimony? And then you can play those portions, but you don't just get to, I don't know if the expression is throw away the bathwater to the child and throw the child in the bathwater. But that's what it appears to me. So I have those two items that I'd like to consider. To answer your question directly, though, yes, I have done it. I do have redactions, but I don't think it's right.
Okay. The court's concern is that given, I don't think in terms of the statements and arguments, my concern is that's my concern. Is that might as well, or if I might have to weigh in on the admissibility of various statements from 28th of January 2015 to February 21st of 15, and it might just be more appropriate. So I choose just documented more on Thursday. The other thing that has the state identified the actions for achieving 10 for 2015?
Yes, Ron.
Okay, so it's possible maybe I can do something more for more listen to whatever it is that you see. Private. Is an administrative data for you all. Are there other statements that you identified that you potentially want to have us look at?
So the only other are the jail calls. So we provide jail calls that we intend using interviews that are left for the and then
Yeah. As a collective group,
10 minutes, so,
15 minutes each.
yeah. So roughly. 150, about.
2.5 hours. All right, council, anything further? What I think I'm going to do is not, she actually strong position. Excuse our jurors. Not sure. Okay, anything else for any Jacob, what do you want before we,
That's a big pile, actually, so. Stay in. Being books, not. It's just a courtesy.
Okay, we'll take it. Okay, they'll get e-file tomorrow, so we'll take it. Anything further? All right, we'll see you tomorrow morning. For we'll see you tomorrow morning. See you.
All right.
Oh, awesome.
That was from yesterday. Let me show you from today. 1 second, guys. All right, guys, let me go ahead and go do this. This is from today, guys. Can we stop the mess in the chat, please? Can we please stop the mess in the chat?
Morning.
It's one,
Morning. Okay, Mr. Kendrick and Mr. Henderson. How's Mr. Weinstein? All right. Mr. Yu and Mr. Matthews, Junior and Senior. Good morning, gentlemen. Mr. Nichols and Mr. Harvey and Mr. Swan. Good morning. Mr. Ryan, Mr. Williams. Good morning. All right. Mr. Atkins and Ms. Hilton and Ms. Knight. Good morning.
good morning.
Okay, all right. First order of business to take, is to take, I have two, motions to recuse, one, by Senator Williams, yesterday. And it's the court business. Another one has been filed under the standing indictment, indictment 22/135/2. One stated that motion to recuse the filed. And I get the lawyers, principal lawyer, and by the social purpose record.
Judge Warren Gage Bank from the Martin's office. Her team's also here. Mr. Collins, Mr. Redding, Ms. Morgan, and Mr.
Okay, as it pertains to your motion, Mr. Banks, so on behalf of everyone that's here, I'm going to just take up the issue of the recused one, I'm going to defer the issue of the motion to quash this. Okay, so I'm not going to take up any, I can't do it anyways, because, the rules require me to go ahead and deal with the motion to recuse to begin. So I've ceased out, any business, and that's why I had Mr. Chamberlain reach out to you last night and counsel for you all to be here this morning so I could take this up. Your motion actually was filed last Friday.
That's correct.
At 10:40 p.m. It didn't appear in the system, however, as sometimes honestly it happens, until sometime on Monday evening. So When I started reading Mr. Steele's affidavit last night, we put on notice that there's possibly another affidavit out there, it's not a motion. So that's what I made the call, okay? So that's how we got here with this. So, did you all attempt to send me independently another, copy of that? Or-
We did not, Judge, I don't.
Okay.
Not.
No harm,
Should have
no
filed.
harm, no foul, no. So, no, I just wanted to know if you had attempted to do so, because we would certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard the promotion.
Sure.
So just, time that, I just want to. Taking a look at. This applies to both motions, both motions that we filed to recuse the court, or disqualify the court. Recusal of the by Superior Court judge is governed by Uniform Superior Court 25, etc. 25.1 provides that all motions to recuse the disqualified judge presiding in a particular case or proceeding shall be timely filed promptly, and all evidence thereon shall be presented by a prompting affidavit, which will set fully assert that upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the applicant first learned of the alleged grounds for disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause is shown for the failure to meet such time requirements in any Georgia 25. Final vote for both sets of wishes. And finally, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the ground. No power to do anything else. And Robinson versus the state. The three threshold determinations that the trial judge made regarding the motion to recuse are whether it's timely filed, whether the affidavit remains supported sufficient, and whether some or all of that supporting affidavit are true. Recusal is warranted, and that is Jaffrey versus the state 304 7477 2016. The judge finds any three of the conditions have been met. No, sorry. If the judge finds that all three conditions, he must refer the motion to another judge to hear the motion. But any one of the conditions is not met, there is no error in not in the motion. Motions to refuse are being considered by the purpose of the each one of the factors. This is the case for Mr. Steele's motion and for shortness, Mr. Banks' motion. I find both the time to file Mr. Steele's motion is to back file on Monday, this past Monday. The 17th of June. I find Mr. Banks' motion on behalf of Ms. Buffett was timely filed and it was filed on the filed on the 14th of June. Second, I find that in addressing the legal sufficiency of the affidavit, that means was it sworn, was it sworn for notaries in proper form? I find Mr. Williams and Ms. Farmer's motions to be, I should say, affidavits to be proper. The third thing that should be used in my review is the legal sufficiency of your grounds of the motion. And And here's where, the court finds that upon review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions, their assertions and legal conclusions which are sufficient for the court to grant your motion at this point in time and refer to another judge to refer to her. So I'm going to deny the motion at this point in time. That's all. Baptiste versus the state. Just because adverse rulings have been made, doesn't mean that what stops. So I'm going to make that, reduce both of your of the motions to accuse to an order, and I will file that so you can take whatever steps you need to necessary. But I don't get into anything about the affidavit itself. Argument on that is read it, as long as you're completed. And if I find it to be not sufficient on its face, I just not much politics about it. No, I won't grant motions for a certificate from me, and that's what we're on this one. Anything else, Mr. Banks?
If I could just briefly be heard, Judge. And I'm not trying to, I understand the courtroom and we'll proceed as we see fit to take issue, of course, characterization about the legal insufficiency of the affidavits.
Well, that's fine. It's reviewed on appeal. Sure. It can certainly be, I can of course talk about my rules for use of discretion.
Certainly, I understand that, Judge. And stating that, Judge, I would just say that one of the issues that is raised in our application, because our motion is to accuse you from the contempt proceeding, not
we finished the director of the complex. The other issues that have been raised, as I told some of the other lawyers here, there is a transcript of what occurred in the ex parte method. Rules, in fact, authorized defense counsel privilege review and see what's.
Okay. Iva, I don't know if you understand what what the purpose of this video is for. It's for reaction from Thug's view and whoever else that we mentioned. This is not for listening purposes because you have the live view that occurred today to look at. This is from my personal camera. It's not for audio consumption. It's for visual consumption of the defendant's view and reaction. Okay? And I know I've told everyone this, and I think Nuna has been putting that in there to show it, that this is not for that purpose. Okay? It's not for that purpose. It's for the purpose of just seeing the reaction from the defendant. Okay? I know you come in here to complain about the audio, but that's not the purpose of it.
be disclosed in terms of impeachment and or Brady. And for that, and I will do that, and then, so if that pertains, or that issue affects you, then certainly that may be something. Time you'll be able to have.
Well, I appreciate the court's time. We can certainly give up on our brief.
Yeah.
That's part of it.
Okay, all right. So I will the court will reach out to you on two things. One, the ability to take a look at, the ex parte, transcript and review it, for the appropriate parts of the court law. And then, also for the issues. I know that it's supposed to be done this Tuesday, but I doubt it will probably happen this coming Tuesday.
If I just can say, again, Judge, I know I've already said that that concerns the issue of being witness to the proceeding. We don't believe that that's a fair allegation. We believe that would be an established fact that the jury will also.
I can't see it. It's not something I can argue with you at this point in time. No, sir. You are an advocate for your client, sure, it's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel, we made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I think my you said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order and you can take what you want to. Okay? All right. Thank you, sir. All right. Mr. Steele, similarly, I'll use what I mentioned to overview.
Keisha, that's Attorney Westmoreland.
That's particularly needed review.
That's Attorney Westmoreland.
Anything else?
Hey, Mike. AJ, I know who it is. I know exactly what happened. AJ, I know exactly what happened.
What we reconsider, and if nothing else, keep it from getting paragraph 12. You assert not fair assertion or legal conclusion, but you made facts that we specifically.
It was not Kayla, y'all. It was not Kayla. I know exactly what happened.
Thanks. Okay. Warnings. Motion where a person that they represent is in meeting as part of the court and others, the prosecutor and witness, and specifically they were completing under Harris, PAR 6 versus State 362 for the appeal 392 Division 1 2022. The lawyers leading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted Mr. Copeland testifying with Mr. Williams. So I handed this court to the witness list. And I'm calling the court as witness and trial. I added lawyers Hilton and Love and the attorney's office to witness list. And when I cross-examine Mr. Copeland that day comes, I'm going to ask about how much pressure we're put on. You're going to be the one instructing the jury. And I just can't imagine. So I just ask you, I'm not adding anything to myself. If you just look at just even paragraph 12, again, if you didn't consume it entirely, I don't think that it needs to be real inclusion there, so what to refuse.
I've read that.
Also, on the transcript, about the recording and the transcript, I don't, I get zero clear.
So, you can't argue about anything such as, may not move, okay? If you have some other basis to ask for the recordings or anything like that, you're gonna have to put those in some other pleading, but at this point, Ms. Weaver's unprepared record, she does that. And, like I said earlier, the record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at those pieces of that particular ex parte transcript, those in chambers. Less anything that is totally, that court considers to be privileged. Once you do that, before you examine this totally. So you'll have everything that should happen. Okay, all right. Okay, all right. Let's turn now to the statements or interviews from January.
Finish our business today, and you get.
You know, okay. Okay, all right, okay. Yes, you may be excused. All right, Ms. Shelton, and council, what matters you have to take up from the interview from the the January 28th, 2015 interview?
Your Honor, last night we sent over, both the February 21st and January 28th redactions. We sent the February 21st one around 7 p.m. and then January 28th around 11:30. We had not heard from the next compliments. I'm not sure if they reviewed them and if they had any additions or disagreements. So we were just waiting for the next compliments.
Okay. Council, the defendants that we identified is now the state has sent you parts from the 28th January interview which you wish to talk about. Mr. Shaw?
Good morning, Your Honor. I had a chance to digest their proposed redactions. I'm happy to talk to him about it. I've been working feverishly on getting together redactions that we believe are warranted. Again, I'd be happy to talk to the state about that. And also be happy to go through them one by one. However, but I can't say at this moment that we cross-reference between this.
Okay, all right, so that's what we're supposed to do this morning. So, does anybody else have flag or wish to be heard on the interview for January 28th? Sure. We're going to cover independently. January 28th, we'll cover February 21st, and then we'll cover the June the 10th interview and then potentially June.
I believe that myself and Attorney Steele, they both have lists. I don't know.
Yeah, what's our
Lists,
okay.
but we're representing different individuals, so the list may vary a little bit. So maybe getting some suggestions from this chair, some suggestions from that chair, and some suggestions from this.
I understand.
Yeah. Okay. Your Honor, do we have 15 minutes to just talk to the state about their
Sure.
list?
Yeah. And if anybody else have any statements that they've identified from the January 28th, February 21st, June 10th, other than Mr. Steele or Mr. Sharp? All right. Okay. All right, then I'll give you all 15 minutes and you can come back and we can just put it down to the 28th of January. It's okay. All right.
This is what today was basically like. Hold on a second, guys. Hold on. Today was pretty boring. Mike, I was just told about that today. Mandarinus. Yeah, I was just told about that today. Yeah, Mariah was there the day before yesterday. I'm talking about on Friday. AJ, what I learned, I can't talk over the live. I'm gonna call you and tell you about it. He's talking to that attorney, the lady attorney that was sitting next to him. Yeah, she is told, truth be told. See how they standing in the way? Look at this. Look at this. They're standing right in my way. Jeremy, I don't know. Look at this. They just standing all in my way. Look at that. They're all in my way, y'all. Look at that. You know that's charm right there. That's standing in my way.
We were focusing on that.
All right, they're in the way. Let me get up. Let me move on. Look at how close he is. Look at that.
And the pages are not the same. So we're working on two different transcripts and we have.
It has to refocus again. Because he stood there so long.
Transcripts in two different videos.
We're trying to focus it. There it is.
What are people cross-reference everything? So this is the time-consuming process. Okay. So we're going to switch this.
If they have the actions, that correspond with the redactions that they we get a CT within the prior for the one to take the next. We get to take
See. But we'll figure out a way to get in the information so they can reference everything was so they can see what we're suggesting. Well, we are near the end of the January 20th statements. I don't anticipate February 21st will take us quite as long. I anticipate that June 10th will be very good. So if you're asking to address those two statements, yeah. Now, but starting June 10th.
Okay, well, let's just bifurcate. As you all told me before, June had one. Okay. But you already identified.
June 10th? Yes.
Okay, all right.
And the good news about June 10th is we're actually working on the same.
Okay, all right. So you don't want me to do that, we're talking this say we can recess.
January 28th and February 21st.
We'll take up the June 10th one. I plan on once we have finished those two. Okay?
Yes.
Fine. That will be right out. Okay. All right, we'll see you all back in, at 12:45, okay?
All right, let's go to the next one, guys. All right, let's go to the next one. This is every time we kept coming back, it was like something else. Yeah, Keisha, he still has it. He still has it.
Sorry.
Yes, sir. President Council for.
All right, Council.
While we just received this council's redaction, however, their redactions are in using an MP4 format, and so we need to convert it to evidence to know exactly what we're talking about. Here's the first question: say that you're ready, this judge you just received it, so we need to compare what they're asking for and see if it even lines up with what we gave them, and there's some may overlap. Here, our two lists. We need time to do that. Now, of course, the meeting at 2, but we probably will be at an hour, not more. They gave us about 13 periods of election. And so we need to play and see what time it is on, so it's gonna be a little tedious of a task to do. And some of them may correspond with the discussion.
But I think we have stuff. So, I believe Mr. Cole, is, copying the MP4 video for the state, so our timestamps make sense. Is that right? Okay, so we're in the process of doing that, and we have to check on, using a different, what the format the state was using, we have to go into that format to look at the other day. So I think both sides are solid on what their own side of the actions are, and now we're entering the stage of checking the other side. For both of them.
You all can continue to work. I'll check back with you all. At 2:10. And I have. 2:30. See on the sheet. All right. So I can read it. We'll see if we can get that. And that will also keep Jake looking out and be consistent. Okay, recess until 2:10, 2:10, I'll shut you off.
You want me to speed it up? You want me to speed it up? Somebody said they're gonna make Woody a shirt this weekend. Did y'all see his IG? Y'all see his IG, y'all? Woody just been like on the move. Look, y'all see his IG? Let me take this off of me. Y'all see his IG? Look at him, y'all. That's just, I mean, not IG, TikTok. This is TikTok. All right, guys, I'm going to end this now because I see my sister's on. And I'm going to go over there. And tomorrow we'll have some more stuff for you guys, okay? As far as the what happened at the ex parte meeting, I have the 411 on that. I have the 411. As I told you before, it wasn't Kayla at all. It was not Kayla. I know the facts, y'all. I know the facts. It wasn't Kayla. You sure it's gonna be called I do not recall? Oh, she's getting off already? Randa's getting off? Oh, okay. Who cares? He's driving now. Who cares? He's driving now. Who's driving now? Who's driving now? Isha. What's going on tomorrow? Nothing. It's the Juneteenth holiday and court is closed tomorrow. We won't have court until Thursday and then half a day on Friday. Can you get a preview? A preview of what? Any weird courtroom interaction? Let's see. I didn't see any. It was a bailiff? No, it wasn't the bailiff. I'm going to give you a hint on something. Remember when Steele said he wants the recording? Remember Steele said he wants the recording? Okay, James, I got a smile. Gosh, I wish I can tell y'all. I wish it was a way that you guys could read my mind. I wish you could read my mind, y'all. I wish you guys could read my mind. Oh my God, I wish you guys could read me. Okay, let me just tell you. Kayla did not tell, but she did confirm when that email came out. Okay? Kayla did not tell. She did not tell. In fact, okay. I'm going to do a... Can you read my mind? I can tell what you're thinking. I wish I could just do members only and tell you guys, but just listen to me. She did not tell, right? Somebody else that was in there told. Blink twice. If it was a wire. She said blink twice if it was a wire. It's not that I'm going to get in trouble. I'm not going to get in trouble because I wasn't in the room, so I can't get in trouble. Now you know we're all nosy and invested. Spill it. I mean, I'm not going to get in trouble, and I'm not going to tell you the person is one of the 14 people that was in that room. One of the 14 people that was in that room. And Kayla was not the one that spilled the beans. He said, if you know, everyone knows, right? If you know, everyone knows, right? You never know. Woody might tell too. Just know it was not her. There was an email. Definitely there was an email. But the email was after the fact. I know all of it, y'all. I just wish I can tell y'all. I wish I can tell y'all exactly what happened. Kayla said no one has guessed it. State or court staff at infamous Sylvia. If he was smart, he would. Don't say nothing, Sylvia. Nah, it was Woody's baby mom. Somebody said, nah, it was his baby mom. It was accidental. You do not say anything. Woody, it was. They're not going to have it on the 25th. It's not going to happen on the 25th. I told you that too already. It's not going to happen. The judge even said it. It's not going to happen on the 25th. It's going to happen after the direct. Do you think he'll give the recording? Well, they're supposed to give the recording. See, what happened, let me tell you something. The recording is going to give everything, right? And it wasn't Miss Weaver. No. It was not Miss Weaver. Y'all don't be trying to put that lady in there. He didn't do it. It was Jack. Somebody said it was Jack. Somebody said it was Jack. It was not Jack. Oh, gosh. That's so funny. We're down to 12. We're down to 12. We were really down to 11 because we said it wasn't Kayla. It wasn't Jack. It wasn't Weaver. I am laughing at you guys at this outrageous answer. The outrageousness in this answer that you guys have given. Oh my God. They said Rico did it, huh? Was Rico in there? Rico did it, right? Rico did it. They've been looking for Rico. Rico did it. Infamous Sylvie, don't want the edited transcript. Okay, back to the recording. Maya, you too much. Listen. Somebody said, who's Jack? Jack is the dog, Vibrant. Jack is the dog. Somebody said, Doug told. Doug was not even in the room. Somebody said, Doug told. Lord have mercy. I'm sticking with the dude next to the weave. You're trying to blame Wesley? Oh Lord. I don't even think Wesley was in the room that day. I don't think he was in court that day. I don't even think he was. Somebody said it was his clerical lord. You talking about the you think it was his main staff person? You think that was who it was? Yeah, crazy. It was the fly on the wall. Oh, you guys don't know the person. You guys don't know the person at all. Mm-mm. You guys don't know the person. The only way you know the person is if you've been in the courtroom. You know the person if you've been in a courtroom. That's the dog. That's the dog. I am Lady 57. That's the dog. The bald man randomly appears sometimes. Oh my God. You just be making up people. Male or female? You know I'm not going to tell you that because then you're going to pick it out. No. Well, it leaves no one else but Jack. TW, you funny. Oh, Miss Sylvia, why does love energy seems off? Because it's a lot of stuff going on now. It's a lot of stuff going on in the court. There's a lot of stuff. There's a lot of stuff going on. The super thick investigator will be looking in the courtroom. You guys. Oh boy, that was standing. Marley said it was the old boy standing between the door looking at Woody. That one. Was that Bean? By the door. You're so silly. Oh my God. I see the numbers going up because they try to find out what I know. I'm not going to tell. I'm going to let somebody else tell it. I'm not going to tell it. I am not going to tell it. Nikki. Oh, gosh, you're making me. Yeah, I need to stop. Man did it. Miss Love told her what happened, and she knew that was a violation and leaked it to Steele. Lord have mercy. Y'all crazy. 14, Judge Kayla Love Hilton. If we guess, will you let us know if it's right? Oh God. Oh my Lord. It's not Weaver. It's not Weaver. It's not Jack. Okay. And it's not Kayla. Okay. Somebody said the court reporter's machine that told. Maya, I wish I could tell y'all, but the reason why I can't tell is because there are people looking at the chat, and also they're gonna try. Oh gosh, there's so much stuff. I wish I can tell y'all. I wish I could. But it's gonna come out. It's gonna come out during the what's the name? It's gonna come out. It's gonna come out. I promise y'all. It's gonna come out. And proof of it is gonna come along with it too. Jesus. Proof of it is gonna come out too. It was not Sergeant Ingram. Will y'all stop it? BB Brew, will you stop that? Oh, Lord, y'all just pulling people's name out. It's gonna come out. I just don't want to be the one to comment to tell it. They're going to hold Sylvia in contempt. I don't want to be part of no contempt because first of all, I was not in that room. So they cannot blame me for nothing because I was not in that room at all. At all. I was not in that room. Freedom of information. Let us know, Auntie. You guys are funny. Oh, you think it will come out? Yeah, definitely it's going to come out. Yeah, it's going to come out. You're going to find out. Definitely. Definitely, you're going to find out. You're going to find out what happened, how it happened. Now, will they be held in contempt? Well, according to what Kayla put down in the paperwork, I don't think it should be held in contempt because it was no secret. Because they didn't tell anybody to keep it secret, and it wasn't done on there was no order placed and not to say anything. And so, and the only person they told a person that's part of the case. It was not the dude at the door. Oh my God. I wonder would these people lose their position. Just wonder. If Steele is asking for a recording, is the judge doing his own investigation and recovering something? Ooh. Infamous Sylvie, don't let them lie to us. Oh, I won't let them lie to y'all. Once this is over, once said they do that reporting, if they don't come out and tell you, I'll tell y'all then. Okay? That's Infamous Sylvia 72. He had his mind set on it being Miss Kayla. I'm so glad it isn't her. No, it was not her. Miss Love been missing in action. I think it was Fanny for real. You think it was Fanny that told? Oh, Lord. Kayla sent email to the first lawyer, but he still, yeah, was CC. You guys got some information, man. How do y'all know some of this stuff? Was it done purposely? Yes. It wasn't an accident. It was done purposely. Oh, Jesse, what in the world? Jesse said officers told to turn off phone cameras and one. Hold on. Let me go back up. Let me read what Jesse said. Jesse, where you getting that from? Jesse said, officers were told to turn off camera and one didn't and had a conscience. Really, Jesse? Where are you getting that from? Someone who worked for Trump told. Y'all crazy. Oh my God. Do the Five Guys charge talk to one another? Yes, they talk to one another. Yes, they talk to one another. I think it was a white attorney that sits in the middle of Hilton and Love. Tasha says, but he said he's gonna redact some certain stuff. Well, this is gonna be crazy. Okay, let me just tell you what I found out about this whole craziness. I found out, this is me asking questions, right? I found out that if this situation right here causes the case to be a mistrial, they cannot retry. You know why? It would be double jeopardy. And because it would be the judge that caused the mistrial. So they can't come back and retry it. That's what I was told today. If it happens to be the judge that does it. If a mistrial happens because of the action of this whole craziness, yeah, that's what they said. That's what they say. If it comes back after all this craziness that the judge did something that was unethical, it's going to be a mistrial and they can't come back because it would be double jeopardy. That's what I was told. Hey, Mike, are you still in here? Mike, are you in here? Mike, are you still in here? He must be gone. It would apply to the defendant because they would put it. Mike gave the name of the term that they would have to file, and that's when the Supreme Court steps in. He gave the term up here when he was in here. Where is he at? Mike, where are you? Mike gave the term, and it's what has to be filed, and the Supreme Court steps in. The writ, he said there was something. There it is. Thank you, B. Drew. This is what it's called right there. I don't know what that means, but writ menandus. That's what has to be done. You said so, Michael told. Lord have mercy. Here we go with this Michael stuff. Yeah. Okay, look it up so we could know it. Okay, menandus. Let's see. And okay, what it means. Okay, a writ mandamus is an order from a court to an interior government official, ordering the government official to properly fulfill their official duty and correct an abuse of discretion. It's American common. Oh, there's a little bug over here. Hold on, let me kill this bug. Hold on. Where's the little bug at? There's a little bug or something. You know how when the light comes on a computer, all kinds of little critters. It's a little like a little fly. Okay, here we go. A writ mandamus is a judicial remedy in the English and American common law system consisting of a law order that command a government official or entity to perform an act it is legally required to perform as part of official duty, or to refrain from performing an act the law prohibits it to doing. So that's what it is. Let me see what another term for that is. Okay, an individual requesting the writ of mandamus, whatever it is, must demonstrate a legitimate entitlement to compel the respondent to perform or abstain from a particular action. The duty in question must possess two essential characters. It must be a duty of public nature. Okay. Let's see, what's the other one part? Okay. What do it do? It says a writ mandamus is an order from a court. Okay, we already did that one already. We did that one. Let's see. What circumstances on that? Okay, whenever a public official, officer, or government has done some act that violates the fundamental right of a person, the court would issue a writ of mandamus, restraining the public officer or government from enforcing that order or doing that act against the person whose fundamental right is being violated. Okay, you guys got it now? That's what it means. If the higher court, a motion still put in Supreme Court in January, what got reviewed weeks ago, that's great. It got denied. That one got denied because they said they had no jurisdiction over it. Because it was still in the lower courts. It was part of the trial has not ended. Once the trial ends, that's when they have jurisdiction. But while the trial is going on, they have no jurisdiction unless the judge fill out a certificate of there's a certificate he's supposed to fill out where it allows that higher court to come and step in. Sure he does. His firm specializes in appeals, hence why his wife is counsel for contempt appeal. AJ Cross probably won't be until July 1st. I agree. Cross probably won't be until July 1st, which is the end of next week. If it's a mistrial happen, will the state still charge or try to? Remember, if the judge is the one that causes the mistrial, they can't come back because it would be double jeopardy. It can't come back. That's what I was told. If the reason the mistrial it has to do with the judge is they're not gonna retire. He's scared of that certificate. It's sad. Otherwise, some member who are not in the RICO case. They're all in it. I killed it. I killed the bug. Okay, it was a little tiny bug, y'all. Certificate halt the trial. Yeah. He has the option to not give a certificate. Yeah, he does have the option. It makes sense now. Yeah, UL has caused a mistrial 3 times now, for real. Truth be told, his answer was always fake interpretation of the law. But there is a recording. So even if you're all wasted for the transcript, we will still get the real spill through the recordings. Oh my God. Jeremy! All right, whoever's watching, it didn't come from me. Y'all heard Jeremy put that stuff in there. It didn't come from me. Anybody that's watching, none of this stuff that's being said in this chat came from me. Y'all didn't hear it come out of my mouth. I did not hear it come out of my mouth. That was Jeremy who said it. Now, he must have got it from somebody else. He didn't get it from me. It's not me. Don't be putting it in there. I ain't open up my mouth. Jeremy, spill the bean. Tell it. Tell it all, Jeremy. Where you get the information from? What did you know? What do you know, Jeremy? What do you know? What do you know, Jeremy? Jeremy, you tell. You what do you know? The opinion of the chat is not Sylvia's opinion. What people know in the chat, I never talked to Jeremy on the phone. Go after Jeremy. Don't come after me. Sorry, Jeremy. I'm going to have to throw you under the bus because ain't nobody coming after me. I'm going to have to throw you under the bus. Sorry. Somebody said drop the link. Okay, hold on. Renee said drop the link. Okay, hold on. I'm going to drop the link. The thoughts of the people on the platform has nothing to do with Sylvia. The opinion of the people in the chat has nothing to do with Sylvia. Jeremy, they want you to come to the panel. They want you to spill the bean or what you know. What was y'all watching? Where did y'all get that y'all information from? Y'all didn't watch it? You didn't get it from me. What's the podcast called? Y'all tell me, because I don't know nothing. I don't know anything. Oh, here he come, y'all. Here come Jeremy.
Hey, Auntie.
Hey, Jeremy.
How are you?
I'm fine. How are you?
What's up, team? That was a question.
That was a question, Jeremy? You need to tell us more, Jeremy.
No, to be honest with you, it's just the logic that I use because based off of what Woody had said in Fast Passing, right? And when he was passing by quick, and then
Oh, you must have been in the back room.
oh,
You was in the members only?
of course.
Most members in the members only don't come out in the front side, sir. Didn't you know that?
No. He says multiple things as he's walking by. I'm saying, going back to multiple times, right? That's the only logic I can use is that because we all thought it was Kayla, right? Kayla confirmed, that it wasn't her, right?
Mm-hmm.
So logically, I'm thinking, why wouldn't Euro just release the transcripts? Because if there's nothing to hide, there's nothing to hide. Obviously, to edit things out, right? That would be my assumption, right? So what's the only way that we can know what actually happened there, right? And I came down to a few conclusions. Accidental body cam left on, right? Or
Why body cam?
well, that's just one of my theories, right? The other one was because I've done this in court too. When I'm speaking to lawyers and the prosecutors, I'll keep my iPhone recording because I don't ever want it to be my word versus theirs. You get what I'm saying? On anything, I've just learned that in general with dealing with, his when it's your word versus theirs, so to speak. So that would be the logical thing, and I think that's why Steele and them aren't worried about the version that comes out. They're asking for it, but they're not worried about it because there's a recording with everything that was said and done on there. That's my opinion. AJ, you agree? Chat fam, you guys agree? That'd be the only logical thing. And now it comes down to who would do that. Now, I mean, I don't know, the way that Love and Hilton been going at it. I really think it's someone we really didn't even think it was at first, who knew it was wrong, who knew that it could come back and bite them. So they played both sides of the field. That's my opinion.
Who you think played both sides of the field?
Either Hilton, as crazy as it sounds, I could see Miss Love doing it.
Why?
Because
Love? You think Love would do that?
She comes off as someone who would steal something from you and help you look for it. And prosecute someone who she know didn't do it. That's my opinion. Or I was also thinking it could have, because Jeffrey's beloved.
Look at the numbers are going up. This numbers in this chat is going up. Y'all not gonna get me in this mess.
No.
Look at
Cat,
that. What's going
Cat,
up?
I'm giving you guys my multiple assumptions of what went through my head. My ultimate conclusion is that regardless of who it was, someone recorded it to save they behind, because who's gonna throw away a career for anybody, right? And that's what I think happened. That's why I asked, was it a mistake or not, or what? Like, those are things I've been trying to think, but that's the only logical thing I can think of. Yeah, that's it, Auntie. Because why else would yeah, there's no other reason why he wouldn't just release the transcripts. And why wouldn't you have the defense there? And plus, Woody's gonna tell it on the stand anyways, because you heard Steele say, I'm gonna ask him on the stand, were you pressured? Were you pressured to give testimony?
But here's the thing. Will he be believed? Because remember, they all saying that he's lying. He's like, Mike, where you been? We've been looking for you. Mike, we've been looking for you. Oh my God. I had to go and pull up my dictionary and stuff because you disappeared on us, Mike.
But I'm thinking it's probably Hilton, because I'm leaning towards Hilton. Hilton, Woody, or yeah, Hilton or Woody is my guess, because the recording had to come from someone in there. And then who shared it is a different story, but the actual recording was from someone in there. Logic would say. So, and did you guys notice today when Love was rolling her eyes, like shaking her head, like mean mugging Hilton, like blatantly on camera? There's some beef going on there. There's something.
You said it was mean mugging her?
Oh yeah, Auntie. Like if you go back and watch the stream.
Hold on, let me see. Hold on. Let's go. Let's go back to the videotape. Hold on, y'all. We're gonna roll it back and see what happened.
Mm-hmm.
So the videotape.
Yeah, towards the at the end of the trial.
Hold on. Hold on, y'all.
And Love seemed like she falling back from the record and everything to protect her, but I just feel like it's a whole bunch of double, but that's how politics are, right? That's how things are, like backstabbing people, double crossing people to get your position and this and that.
Yeah. You're right.
You saw that, Mr. Clean? Yep. And it was blatant, Auntie. It's a look that like she typically gives the defense when they're like giving emotion, but it was directed towards Hilton, to the point where Love was speaking to the Caucasian attorney through him to speak to Hilton. Like they weren't even conversing. She was
Really?
like, yeah, relay this message, punti wooty woo. Like that's what it looked like towards the end.
Okay, hold on a second. Let's see. All right, here we go.
All right, sir.
Not quite what I said. We've identified things that we think need to be redacted.
All right, sir.
Not quite what I said. We've identified things that we think need to be redacted. The problem, the mountain we're climbing is both sides have their own transcript and the pages are not the same. So we're working off two different transcripts and we have converted our files to MP3. They're still going off the evidence reviewer. So we're working off two different transcripts and two different videos with different timestamps. So we've figured out a system to try to make it work is just a little bit time consuming. So we're working on it. We have identified, and we're going to get to the state what our proposed redactions are, and we still have to cross-reference their redactions. So it's just a time consuming process.
Okay,
We're working as quickly as we can.
If they have redactions that they have identified at this point and they would like to turn them over so we can review them, and if they turn over both the transcript that they are using and the MP3 file that they are using that corresponds with the redactions that they've requested, we could review those. We could at least be reviewing those while they're correlating the ones we've given them to the media that they have and the transcript that they have, so that the downtime isn't a total wash, and we'll be able to make some kind of progress.
all right. Sir?
I will see if we have, we should have a copy of the MP3s. I don't think we have a problem with that. But we'll figure out a way to get them the information so they can reference their materials so they can see what we're suggesting.
Okay,
And we can literally listen to it in their media format, however they give it to us, and we can know whether we agree or disagree with it in the format that they have it right now.
okay. So how much longer we all need?
Well, we are nearing the end of the January 28th statement. I don't anticipate the February 21st will take us quite as long. I anticipate the June 10th will be very lengthy. So if you're asking to address those two statements, I think that we could be ready in probably 45 minutes to an hour. But regarding June 10th,
Okay, well, let's just bifurcate it. As you all told me before, the June 10th one will take the longest, so.
Right.
But you have identified most of those statements, is that correct?
in June 10th,
Yes.
yes.
Okay, all right.
And the good news about June 10th is we're actually working on the same transcript on that one.
Okay, all right. So do you all want me to give you another 45 minutes? Let's say we recess and have come back at 12:45?
So we'll be discussing the January, which ones will we be discussing?
January 28th and
Oh
February.
yeah, you could
21st.
see it, Jeremy.
Let them at a minimum.
Jeremy, you're right. You could see the tension.
Yeah, I'll have to
I told you, Auntie.
pick up the June
You're
10th
right. I
one,
wasn't
and
paying
I
attention
planned on.
in there.
once we
Rewind
kinda
that like
finish those
15
two,
seconds,
we can
like
kinda
Hold on,
so
hold
like
on.
everyone can see it.
Hold on, y'all see it? Hold on.
Yes, John.
All right.
Hold
That
on.
work for everybody else?
But what our proposed redactions are, and we still have
She's
to.
talking-
but we still have
she's
to
talking through the middle
cross-reference their
guy
redactions.
to talk to
So
Hilton. She
it's
wanted
just
to
a
talk to
type of
her.
transcript.
No.
And the pages are not the same. So we're working off two different transcripts, and we have converted our files to MP3. They're still going off the evidence reviewer. So we're working off two different transcripts and two different videos with different timestamps. So we've figured out a system to try to make it work. It's just a little bit time consuming. So we're working on it. We have identified, and we're going to get to the state what our proposed redactions are, and we still have to cross-reference their redactions. So it's just a time consuming process.
Okay,
We're working as quickly as we can.
If they have redactions that they have identified at this point and they would like to turn them over so we can review them, and if they turn over both the transcript that they are using and the MP3 file that they are using that corresponds with the redactions that they've requested, we could review those. We could at least be reviewing those while they're correlating the ones we've given them to the media that they have and the transcript that they have, so that the downtime isn't a total wash, and we'll be able to make some kind of progress.
all right. Sir?
I will see if we have, we should have a copy.
Oh, look, you see her face? Oh my
But we'll figure out a way to,
Yeah,
we'll
y'all
figure out a
see
way
her
to
face?
get them the
When she
information so
looked
they
at her,
can reference their
you see
materials
that?
so they can see what we're suggesting.
Okay.
And we can literally listen to it in their media format, however they give it to us, and we can know whether we agree.
Oh my God, I did not see that.
Okay.
I did not see that.
So how much longer will you all need?
Jeremy.
Well, we are nearing the end of the January 28th statement. I don't anticipate the February 21st will take us quite as long. I anticipate the June 10th will be very lengthy. So if you're asking to address those two statements, I think that we could be ready in probably 45 minutes to an hour. But regarding June 10th,
Okay, well, let's just bifurcate it. As you all told me
No pace,
before,
no pace.
the June 10th one will take the longest. So,
Right.
but you have identified most of
Wait.
those statements. Is that correct?
in June 10th,
Yes.
yes.
Okay. All right.
Oh, she see her. Oh my
And the good news about
God.
June 10th is we're actually working on the same transcript on that one.
Okay. All right. So do you all want me to give you another 45 minutes? Let's say we recess and have come back at 12:45.
So we'll be discussing the January, which ones will we be discussing?
January 28th and February
February
20th.
21st. At a minimum.
Okay.
Yeah, I'll have
What
to.
did Lamar say? Hold on. Let me
We'll
go
take
up.
up the June 10th one. I had planned on, once we kind of finish those two, we can kind of get an idea what would be an appropriate schedule. Okay.
Yes, sir.
She was?
That work for everybody else? Okay.
What did
All
she
right.
say on that?
All right. We'll
Lamar?
see you all back at 12:45. Okay. All right. Okay. We're in recess.
Okay, let me go fast. I did not see that. And then she didn't come back after that. You notice she didn't come back when it came back to court.
Your Honor, we just received defense counsel's redactions. However, their redactions are in
She didn't
using
come back.
an MP4 format. And so we need to convert it to evidence reviewer so we can know exactly what we're talking about. To answer the court's question, the state isn't ready at this juncture just because we just received it. And so we need to compare what they're asking for and see if it even lines up with what we gave them, because it appears that some may overlap. We just have not had the opportunity to sit down and compare our two lists. And so we would need time to do
Okay. Jeremy.
that.
Jeremy, thank you for bringing that to my attention. I didn't even know that they were having such sourpuss faces like
No
that.
worries, Auntie. I just want to tap in with you. Thank you. Thank you as always for being boots on the ground. You know, I'll be tuned in.
Thank you.
All love.
Wow. Love you too. All right, guys. I'm about to get off this live. You guys gave me some stuff today. Lord have mercy. What's the state investigator's name? Which one? There's a couple of them. Did we share the picture? What picture, Bob? I shared it in the members only. The picture that Thug's mom gave me. That one. It's in members only. Infamous. So where are you supposed to wait until July 1st to find out who told? Maya. Don't get me in trouble, Maya. Please don't get me in trouble. Uh, Maya, don't you dare try. Okay, TW said that she already know. Thank you, TW. Thank you for getting me out of this mess that Maya tried to get me in. It's been mentioned about Hilton being upset and even crying, but I don't recall seeing why. I don't know why she was crying that day. I don't know, but she was crying. You going live tomorrow? Yeah, I'm gonna be going live. Guys, I have so much footage that you guys, if we could be here for days just for looking at different footage and stuff like that. We can do that. I still have not read Steele's motion. And guess what, y'all? There's going to be another motion submitted. There's going to be another motion submitted. And it's going to be submitted after. Let me see. I got to go tomorrow, not tomorrow. There's no court tomorrow. Thursday, I'm going to go downstairs and check the records for you guys. I did tell you guys there's no one filed for appeal. No one filed for the appeal. And on the 20th, Jeffrey's brother trial starts. I'll be up there for that as well. Okay. And shout out again to I got emotional earlier because I feel so grateful, y'all. I feel so grateful. Yes, the death one. Yeah. I feel so grateful that you guys y'all just be yeah, I did need another camera. See, the camera's right here, y'all. There go the camera. This is it right here. See the camera. The new camera. And it has the little buffing thing, so it keeps out that all that noise. And then I guess once I get a mic, somebody said they were going to do a mic for me. So once I get the mic going to go right here. The mic going to go right here. And this is the new camera. This is my old camera. This is the new camera. My old camera, the new camera. So we're going to have a few cameras. I'm going to see if Dallas going to let me use hers so I can have 3 cameras. One on one on Love and, their table. One on the defense and one on the witness, all going at the same time. I didn't make the choice. The person purchased the Sony. See, I have a Canon. Okay, that sounds good, Jeremy. That sounds good. Oh. But isn't God amazing, y'all? God is so amazing. I did not expect it at all. I mean, they even got me extra batteries. And the terabyte thing for backup. 5 terabyte. I even got that. It's amazing. Amazing. Kayla represented by GDLA. I don't know. Sylvia, infamous Sylvia, was the person who had sent to get checked what room they were in that would be in court. Huh? Sylvia, infamous Sylvia. T was the person who had sent to go check what room they were in that would be in court. You know, Rick. You know what, Rick? You need to go sit down somewhere. Dee said, it seems like they really targeting his family. You deserve the recognition. It's about time folks know who you are and have covered those Doug, R. Kelly, Boosie, Cardi B, etc. Dee, it seemed like they really, okay, we got that one. How sweet. Hi, Jeremy. This infamous Sylvia Tugget Daily has his filing on his X page. Which one? Which filing? I have Steele's filing, but I was telling you guys there's a new filing coming up. Let's see. Lunch on me. I've never been to Atlanta, but would love to attend a day with you and eat some local cuisine. I'll message you and go from there, Auntie. Okay, Jeremy. So who you sent, Sylvia? So who you sent? Who I sent where? I didn't send anybody. Yeah, stop it. It was Hilton because it was Brady information. She had to tell. Oh Lord. Okay, where's Lamar? Lamar. What did Lamar just recently say? Lamar said Kayla said earlier in her interview, nobody who been covering this theory has been right yet. Okay, hold on. Let me go. What where was she at? Where were y'all at? The podcast. What podcast was you guys at? Maya, I'm not telling y'all to guess. She said it was 14 people. Yeah, it was 14 people. It was in the paperwork. It was in the paperwork that I read yesterday. Tall class, you better get moving on planning your ISL end of the trial party plans in the ATL with Sylvia. It wasn't Hilton because she participated and she wouldn't press charges on Woody if he lied. Dang, why them people? Yeah, I know what the lie was trying to get Woody to join today. I want to read up on that. Talk that loyal, the lawyer you know. The lawyer you know, that's where he was at. She was at. Hold on. You know I know him, right? Him and I did something together like years ago when R. Kelly's trial was going on. This is when he had like so many little bit of numbers, and now he's rocking it. He got hundreds of thousands. Somebody said the judge told. They come up with all kinds. Okay. Hold on a second. Somebody said black guy from Texas. It was it was on Talk That Law. Talk That Law? Okay, hold on. He said Talk That Law? I'm trying to find it for you. Is it talk that law? Okay.
It or not, whether they can prove it, that shows the defendant is guilty or that he's innocent. The cases.
Okay, we gotta get Kayla. Looking for the part with Kayla.
A lot of interviews, so I just said, let me jump back in and see, get my public speaking back on. So, oh yeah, I remember when I first started trying cases, I was like, oh man, it's a the reason the meeting was planned so late on Monday that they didn't have time to tell the other lawyers, don't come in right now, come in later on. Y'all stay at home so we can have a meeting. I think the meeting must have been planned on impromptu, without much preparation Monday morning when everybody showed up. But I think, but what was the issue you were? Somebody said they had it planned over the weekend. But the person that said they got it planned over the weekend, I think.
I don't see her. She was on there? I don't see her, y'all. Oh, there she go. There she go. There she go. There she go.
Gang was a prosecutor when I was a prosecutor.
Oh. Oh, okay. So are you moving
Hold on.
to Texas?
Hold on. There we go.
For joining us,
Hold on. I see you. Hold on. Shout out to the talk that law.
Personal injury with a million.
I don't want no criminal cases.
I know that's right. Especially after now, they can have it.
Right.
Yeah. Well, I definitely appreciate you coming on and showing your face so we can know it's you. I know you.
Yep, it's me.
Okay. Well, I don't ask you nothing. Is there anything you want to say? Or no, you just chill.
No, just going to different channels, just getting a vibe of what people think. It's just so funny to me. Everybody has all of these theories and.
Right. Well, and be dead wrong.
Nobody has. I haven't seen one person has who I'm like, oh, they know. Like, not one person has said what actually happened.
Oh, really? Oh, okay. Okay. Wow. Well, this is gonna be interesting, man.
It's gonna be interesting, but I don't think the 25th is gonna happen.
He shouldn't even did in the first place. And I know this is not you saying this, so you don't have to adopt my statements, but it seemed to me that when you were first trying to get off the case, he didn't want to let you go because he already had in his mind that he was trying to keep you there for this show cause hearing.
He was trying to punish me.
Yeah, that's what it was. Yeah. To be clear, that's exactly what it was. He didn't want to let you go. And then when the other lawyer stepped in and said, hey, Judge, you got the rules wrong, as usual, and that's me saying it, not you. He's like, well, you can go. Then he handed you a paper. I already knew he was on some, I'm gonna keep it clean while you up there, because I don't want them to say, you're saying what I'm saying. But that was it. But
just point blank, period. Like, I'm gonna say this is that Woody, like, me, the agreement was always that I was only representing him while he was in custody. Once they agreed to let him out of custody, the whole fight was because he was trying to help me get off the case. Even he knew that the judge was wrong.
That was my first theory, because a lot of times when we work with clients, we can talk to them about
Okay. There's no bad blood at all.
Oh, okay.
It was just like everybody, even he couldn't believe what was
Oh, okay. The way his demeanor is, and he, dramatic with it. Yeah. All right. Yeah. I was thinking, I was like, okay, if it was my client, I tell my client, hey, the judge is not gonna let me off unless you, get on board. And a lot of times, I never had a client to just say, if they know what I want to do, they'll be like, oh, okay, so this is what I gotta do. I'm like, yeah, that's what you gotta do. And then we gonna do it.
But that was always the understanding. It was no, I didn't do anything like all these theories about it. There was no anything like that.
Oh, okay. I was thinking that you were like a substitute attorney, even if that's the proper term.
The thing about it is me and Melnick are friends, and he knew I had previously had a relationship with Woody. So when he asked me, it was no problem because I had previously represented him. It is what it is. So what it didn't matter. Their agreement was once he was once he purged himself by testifying that he would no longer need representation.
Right. Okay. So, and I guess that makes sense. As far as, I was thinking that when you came in for Melnick, you were there for Melnick during the entire time. But from my understanding, he was giving use immunity, and as we know, use immunity covers, what you say on the stand. They can't use that against you, but it's not for immunity. So I was thinking, does he need a lawyer there outside of, because he might say something on the stand that, that has him locked up. So that was my concern for him. He needed an attorney there. But if you and Melnick had to understand that, hey, I'm only here until he purges his contempt. And he wants this contempt purged, I'm gone. And that makes sense because I don't think you should have been locked into that case while Melnick was gone for, a week, 2 weeks. That ain't right.
Right.
You see what you were doing a favor.
Doing a no good.
You were doing a favor and almost got trapped. They ain't gonna let you go. Yeah. But,
I just say this, and the last thing is that everything happens for a reason, and it happened the way it was supposed to happen.
Right. I agree. I think you did the best you could with what you had to work with. And like you said, we don't know. We're speculating what happened in that meeting. And from my understanding, in the motion, you were present in the meeting, so we don't know what was said. We don't know who came to who defense, or were you representing Woody, or were you not? It's so many questions that we were on.
I'm going to answer all of them, but I will say this: it was 14 people in the room. 14.
Okay. And the judge called, I say attorney-client privilege when it's 14 people in the room. There's no confidence in that whatsoever. But that's me. But thank you so much.
All right, no problem.
Hopefully we get you back one day. All right, thanks, bye.
She didn't say much. She didn't say much, y'all. Hey, Black Hacker, how are you doing? She didn't say much. She just said there was 14 people in the room. AR, I am not messing with you either. Don't, AR, I did not say that. AR trying to get me caught up in this. When did Ashley do an interview? When did Ashley do an interview? Recently? Who shouted me out, Michael? I want to shout them out too. Y'all don't, what are y'all talking about? Stop trying to put me involved in that. Talking about I sent somebody to the room. No, I did not. I didn't send anybody to no room. Why there's no court on the 25th? There's court. Why you said there's no court? There's court. Who was on Melanie King? What's the name? Ashley Merchant was on Ebony King. Melanie King. All right, I'm about to go. I gotta go to bed. Good night, everybody. Jerome said, you did say you was nosy. I might was in the meeting too. LOL. Oh my God, y'all stop it. Y'all tried to get me caught up in there. Hopefully it's a smart juror to see clearly reasonable doubt and find them not guilty because a judge will never recuse or grant mistrial. There's not going to be an ex parte hearing on the 25th. You know why? Because the judge said they're going to have to do it after the direct. And direct is no way near going to be finished on Tuesday because they're going to be listening to a 15-hour recording and 2 hours worth of phone calls. So you know for a fact it's not going to happen. Y'all know what. Good night, everybody. I'm going to bed. Good night. Y'all keep coming up in this chat. Good night.